If you're an American senior, or you're helping a parent, spouse, or grandparent manage credit card bills, August 2026 is a smart time to slow down and look closely at the next statement before you assume everything on it is routine. And before we go any further, I want to be completely straight with you, because when we're talking about seniors, debt, fixed income, and monthly bills, you deserve clarity, not clickbait. There is not one single brand new federal law passed only for seniors that suddenly rewrites every credit card account in America this month. What actually exists is a group of confirmed, already enforceable consumer protections and account rules that can affect what you see on your next statement, how much time you have to react, what fees can hit you, and what your rights are if something looks wrong. Today I'm going to walk you through 5 of the biggest ones, and for each point I'll tell you what is really protected, what many older Americans misunderstand, and what you should actually do before the next bill closes or comes due. So if you want, drop a comment with the year you were born, because that helps put these rules in context, especially if you're retired, living on Social Security, drawing from savings, or helping manage an aging parent's account. And stay with me, because the 4th point is the one that confuses seniors more than almost anything else, especially people who suddenly see a higher rate, a lower credit limit, or a fee they didn't expect and assume the bank can just do anything it wants. It can't. Let's start with the first change you need to understand, and this one matters to almost everybody carrying a balance. Your card issuer generally cannot just spring a major APR or fee change on you overnight. Under federal credit card rules, significant changes in terms typically require advance notice, generally 45 days before they take effect. And that matters more for seniors than people realize, because many older adults don't review every piece of mail the week it arrives. A lot of people think the moment a bank wants to raise your rate, add a new fee structure, or change a major term, it can simply print it on this month's bill and you're stuck with it. That's not how it is supposed to work. In many cases, the company has to warn you in writing ahead of time, and the notice is not just a courtesy, it is your reaction window. In some situations, that notice must also explain that you may have the right to reject the change before it becomes effective, even though rejecting it can mean your account gets closed to new purchases or future advances. That's why this first point is not just legal trivia. For a senior on a fixed income, one unopened envelope or one statement page skipped in a hurry can be the difference between planning calmly and getting blindsided by a higher cost of borrowing next month. And there's another part of this first point that matters before your next statement due date. Card companies generally cannot treat your payment as late if they receive it by 5 p.m. on the due date shown on the bill, or by the next business day if the due date falls when they are not receiving mail, like a Sunday or holiday. That may sound basic, but seniors are one of the groups most likely to rely on mailed payments, bank bill pay, or manual habits built years ago. The real-world consequence is simple. Mailing a check on the due date is not the same as the company receiving it on time. So the practical move here is not panic, it's procedure. Read the first page of your next statement slowly. Look for any change in terms section, compare the APR and fee language to the prior month, and if you still mail payments, give yourself more lead time than you think you need. The second change is hidden in plain sight on nearly every statement and gets ignored by a huge number of retirees. The minimum payment warning and payoff estimate section. Federal rules require credit card statements to show a bold warning telling you that if you only make the minimum payment, you will pay more in interest and it will take longer to pay off the balance. In many cases, the statement must also estimate how long repayment would take and what the total cost could look like if you keep paying only the minimum. And if your payment is so low that it won't really dig you out, the warning can be even harsher, basically telling you that even with no new charges, you may never pay the balance off at that pace because the payment is being swallowed by interest. That is one of the most important consumer protections on the page, yet it's the part many seniors skip because it looks repetitive or because they assume it's generic legal language that doesn't apply to them. But it absolutely does. If you're 68, 74, 81, or older and using a card to bridge grocery costs, prescriptions, utilities, or surprise car repairs, that box is not there for decoration. It is showing you whether the payment habit you're relying on is slowly solving the problem or quietly locking you into years of interest. Many older Americans were raised to think that sending something every month means they are doing the responsible thing, and morally speaking, of course that feels true. But mathematically, a minimum payment can sometimes protect the bank more than it protects you. That's the misunderstanding. The minimum due is the amount needed to keep the account from going immediately delinquent. It is not a recommendation that the balance is healthy or manageable. So the practical step here is to stop glancing at the minimum and start comparing it with the total balance, the interest charge, and the repayment estimate. If the statement includes a toll-free number for credit counseling information, don't treat that as a sign of failure either. Treat it as a tool. Seniors often wait too long to ask for help because they think counseling is only for someone in full financial collapse. In reality, the strongest time to get help is before the account gets into repeated late fees or penalty pricing. And this is why these first two changes matter together. If your terms are changing and you're also drifting into minimum payment territory, your next statement is not just a bill. It is an early warning system. Read it like one. Source. Now let's move into the third, fourth, and fifth changes, because this is where seniors can either protect themselves quickly or lose ground without realizing it until months later. The third change is your billing error and dispute clock. And this one is incredibly important if you ever see a charge you don't recognize, a duplicate amount, a service you canceled, a medication order that never arrived, a travel charge that looks wrong, or even a scam purchase made after someone got hold of your card number. Under federal billing error rules, you generally have to get your written dispute to the creditor no later than 60 days after the first statement that shows the problem was sent to you. That 60-day window is one of the most important deadlines in consumer credit, and yet many seniors assume they can wait and mention it next month or handle it casually with one quick phone call whenever they get around to it. Don't count on that. The law is much stronger when you act promptly and use the billing inquiry route the issuer provides. And once the creditor receives a proper billing error notice, it generally has to acknowledge your complaint within 30 days unless it resolves it sooner, and it generally has to complete the resolution process within 2 billing cycles, not more than 90 days. That means you are not powerless, but you do have to move. If you manage bills for an older parent, this is one of the smartest habits you can build. The day a strange charge appears, circle it, document it, and start the dispute process right away instead of waiting for a pattern. The fourth change, and yes, this is the one that trips people up, is what happens when you're late, your rate jumps, or your credit limit suddenly gets cut. Many seniors assume that if the bank raises the APR to a penalty rate, that higher rate can simply stay forever no matter what. That is not the whole story. Federal rules require issuers to reevaluate certain rate increases and reduce the APR when appropriate if the factors that justify the higher rate no longer support it. In plain language, a penalty-style rate increase is not supposed to become an automatic life sentence if your payment behavior improves and the account no longer looks as risky as it did. On top of that, there are limits on fees. A late fee generally cannot exceed the required minimum payment due immediately before that fee is assessed. That matters because some seniors think a tiny missed minimum can legally turn into an unlimited pile-on. It can't. And here's the other detail that shocks people. If a card issuer lowers your credit limit, it generally cannot immediately start charging over the limit fees or a penalty rate just because your old balance now sits above the new lower limit, at least not without proper notice, and not if you haven't opted into over-limit treatment. This is why point 4 causes so much confusion. A senior checks the account, sees a lower credit line, sees usage suddenly looks high, and panics, assuming the bank now has total freedom to punish the account instantly. But the rules are more structured than that. So what should you do? If you see a rate jump, don't just pay in silence and assume it's permanent. Compare the current APR to older statements. Check the notice language and call the issuer with specific questions. Why did the rate increase? When will it be reviewed? What behavior is required for reconsideration? And was there a recent limit reduction notice? That one phone call can clarify more than weeks of worry. And now the fifth change, the one that matters if credit card trouble becomes collection trouble. Seniors across America live with a real fear that one bad season with debt means their Social Security check can just be snatched away by a private credit card collector. In most ordinary consumer debt situations, that is not how it works. Before a private debt collector can take money tied to federal benefits, There are court procedures, and if your Social Security or certain other federal benefits are directly deposited, your bank generally must automatically protect 2 months' worth of those direct deposited benefits when a garnishment order hits the account. That protection is not the same as saying every dollar in the account is untouchable, and it is definitely not the same as saying all debts disappear. If you have more than 2 months of protected benefits sitting there, the extra amount may be at risk depending on the situation. And if you deposit paper benefit checks yourself instead of using direct deposit, you lose an important layer of automatic protection. That is the misunderstanding seniors need to hear clearly. The protection is strongest when benefits are directly deposited and identifiable. And if collectors start calling, there are still rules. They generally cannot call more than 7 times within 7 days about a particular debt, and they are generally presumed to violate the law if they call within 7 days after already having a telephone conversation with you about that same debt. They also generally cannot call before 8 a.m. or after 9 p.m., and you can tell them when and where not to contact you. So if point 5 applies to you or someone you love, the practical steps are immediate and concrete. Keep federal benefits on direct deposit. Do not ignore court papers, save voicemails, keep a written log of collector calls, and never assume harassment means helplessness. So let's bring all 5 changes together in plain English. First, big changes to credit card terms generally are not supposed to arrive without warning, and that 45-day notice window matters. Second, the minimum payment warning on your statement is there to show the real cost of staying in revolving debt, not to fill space. Third, billing errors and suspicious charges have a real federal deadline, so you need to dispute quickly and in writing. Fourth, higher rates, late fees, and lower credit limits are governed by rules, not just bank mood, and you should challenge confusion instead of surrendering to it. And fifth, if debt spills into collections, older Americans still have rights, including important protections tied to directly deposited Social Security benefits and limits on collector call behavior. None of this means every senior is suddenly safe from expensive debt, and none of it means credit card companies have become charitable. What it does mean is that your next statement is more than a reminder to pay. It is a legal document full of signals about your rights, your risks, and your next best move. Before you act on any fear, any rumor, or any viral headline, verify what applies to your account directly by reviewing your statement, the notices attached to it, and the official federal guidance behind these protections. And if this script helped clear things up, share it with another senior, caregiver, or adult child who helps with bills, because one overlooked statement is all it takes for a manageable account to become a stressful one.